My name is Kathy Youngman, and I'm the Vice President of the Central Delaware County League and Secretary of the ILO. Um, I want to welcome you to this town hall. This is an exciting time for the League. We are very, very, very busy. And one of the things that we're doing is this national study on the federal judiciary. So I'm just gonna share my slides. This is an important step for the league to do this study. At the last June's convention in the summer of 2024, there were a bunch of us who are on this call who were at the national convention, and the delegates voted overwhelmingly to conduct a one-year study of the federal judiciary. Usually studies take much longer, but the league felt that with the way we can share information so quickly these days and meet virtually, it was better to compress this study into 1 year and get the results and the position completed in time to take action. So before we start, I'd like to take a poll. And I just want to, let me get this poll up. Okay. Can you answer this question? There are two questions here. Have you ever participated in an LWV consensus before today? And this will help us know how basic we have to get in our explanation. So there are 29 people. You can just say, okay, half of you have responded. Can the rest of you respond just to get us a little more information?
Would you put it up again, please?
If you just entered after we started this poll, I don't know if you can participate. Is that what happened?
The questionnaire disappeared, so I would like to answer that I have not.
Okay.
Okay.
All right. So it looks like 81% of you have not participated and 19% have. So I'll do a deeper explanation of how these consensus things work. Can you see the second question that's there? I would like to know how much you know about the federal judiciary because I did not know a lot before I started researching this.
It would not let me say I have a deep knowledge.
Well, I'll count you, Jodine. It looks like one of us of 29, 30 now has a deep knowledge, and 13% know a lot, and 80% know a little bit. And one person is not sure if the Supreme Court is part of the judiciary. It is. Okay, so that gives me a really good idea of where to start. And you can see the results here of the poll. Can you guys see that results?
Yes.
All right, so I'm going to stop that.
Sorry.
Just wanted to let you know that a league position is required for league action. All the advocacy that the league does is based on positions adopted by consensus of the membership. Currently, the league has positions on legislative and executive branches of government, which have been done over the years and a long time ago. But the National League lacks a position on the third branch of government, which is the federal judiciary. So at our national convention in June, we talked about that and decided it really is time for us to have a position on this. So what is a consensus in leagueese? Because the league way is not always understood by everybody. Consensus is the process that's used to arrive at positions on issues. And it's the collective opinion of a substantial number of league members, representative of the membership as a whole, after an objective study is done. Note that a consensus is not a strict vote. It's a collective opinion of a substantial number. So the league, uh, the scope of this study is to develop a long-lasting, and long-lasting in the league way is a way to say that we're going to talk about principle. And we want to develop a long-lasting league position on the federal judiciary as an essential component of the United States democracy. The purpose of this study includes, but is not limited to, addressing concerns and clarifying judicial accountability, transparency, independence, and ethics. So those are the 4 areas that we're going to talk about and discuss today and during our in-person meeting in March. The scope will address the Supreme Court as well as other Article 3 federal courts, and Jodine's going to explain to us later what Article 3 is and what are those other branches of the federal judiciary. And our goal of this study is to develop a position that outlines the values, which are the standards and norms that the League of Women Voters should use in evaluating proposed changes to policies, laws, and regulations about the federal judiciary. So we're talking about the things that we believe in the federal judiciary should do and should be like. And then we can take those standards and norms and evaluate specific proposals in law and proposals to change in regulations. The position should be principle-based in order to ensure that it lasts for many years to come. And it allows us to address a wide variety of issues that will arise in future years. So how is this happening? The Federal Judiciary Study Committee that was established after the convention in June, people volunteered for it. There are judiciary and legal experts on it, as well as a sampling of other people who wanted to be part of this study. They spent 6 months intensively studying the federal judiciary. And they're framing this study for us, and they've given us a series of specific policy papers on specific subjects related to the judiciary that we can study and learn. We're not going to be subject experts, but they're going to give us a non-legal language summary of things that we should take into consideration when we have our March meeting. So they provided all these user-friendly background. And let me just show you this. Can you see this web page that I'm scrolling through? Yeah? Okay.
Yep.
So at the end of this presentation, we will send you the link to this recording as well as the links where you can access all of this information also. So this is, if you look, this is on the LWV.org, the US webpage, under league management. And you find the link to league management at the very bottom of every page on the LWVU.org website. So we'll send you this link, and it has a total outline. It has discussion prompts that we're going to use in our discussion in March. It has the online survey form. We will be filling out a survey after our in-person consensus meeting. It has a study guide to help us learn, and it has a discussion group that we can join. And let me just show you quickly this discussion group. I joined this, and all you have to do is leave your email, and it has all this commentary and discussion within leagues across the country, sharing resources and sharing opinions and asking questions, and it's really so helpful. I was able to find some resources for Jodine that she could include in her meeting today. It's really a good resource.
And SCOTUS blog is really an excellent resource. They will comment on and analyze every major case that goes to the Supreme Court to tell you what it's all about, why it's important and all of that. And it's if you want to really deep dive into the court system, into the Supreme Court, that's a really good site. I used to use it all the time.
So as you scroll down this page, you will see all these policy briefs. If you click on any of these links, and we will send these links to you, you get automatically downloaded a 2-page, non-legalese worded discussion of important ideas about each of these topics. And I would also suggest that if you didn't see this National Town Hall that the National League did on February 4th, that you actually watch this, because they laid out all the issues that have to do with the federal judiciary so well. It was really good. And these are the people who made up that study committee. Okay, so let me get back to my slides. Okay, so here's the timeline for this whole study. And you can see that they did a kickoff webinar in November, and they started posting and sending out materials in December to league members. There was an information session in January for those of us that wanted to attend on how to prep for our consensus meetings. And this month, earlier in this month, they posted all of those resources that I just showed you. So every league across the country is supposed to have these meetings, these kickoff meetings, and then consensus meetings sometime in February and March. And this is today's webinar that we're talking about, our meeting. And then in March, you have the final consensus meeting. We're having ours on March 8th at the Ridley Library. And you should have, you'll get a notification about that soon if you haven't received one. Then April 1st is the deadline for Anne and I and Jodine to fill out the consensus form that National has supplied and send it to National. And then in April and May, the study committee, those names that I showed you on the screen before, will propose a position, a league national position, to the board for a vote. And then in June, that position, if it's approved by the board, will be announced at council at the end of June. And council is what the National League has, a meeting of the board and National League leaders every other year. When there isn't a convention that we all can attend, they have a council to keep league issues moving along for the next year. Does that make sense, everybody, this process? So the consensus is reached through a group discussion and is not a simple majority, nor is it unanimity. Rather, it is an overall sense of the group. That's why we're going to meet for a discussion, as expressed through the exchange of ideas. So the National League sent us some prompts that we can start discussing. And the way the league feels about it, very league-esque, is that there is room for dissent. So that's why we asked for a consensus. And every league will conduct a consensus meeting. We'll answer the same set of 12 consensus questions. So those 12 questions we'll send up to National. They will compile all of the results from each local league that participates and write a policy and present the policy to the board and then to the summer meeting. When we meet on the 8th, we will have a note taker and a timekeeper so we can keep moving in our discussion. Okay, so here are the next steps. The study resources that I showed you and even more, I will send to you, and Mozakowski and I will send to you, as well as the recording of this event. And then on Saturday, March 8th from 1:30 to 3:30, we will meet as a group, as many of you who can make it, at the Ridley Township Public Library. They don't allow food in their meeting rooms. Just giving you a warning, we can't provide snacks. But we can't, you can bring bottles or cans of something to drink if you want for those 2 hours. And then we'll submit our consensus, and then it'll be presented to the board. So, okay. And I made this graphic just to kind of reinforce how we're going to run through this. So the National League, because some of us are visual, like I'm visual, and it's harder for me to get things from written word as it is visual. So the National League first gathers all of our responses, and it adds it to the National League document called Impact on Issues. And that is a compilation that comes out every 2 years, that every issue that might come up, you can find in the Impact on Issues, and all of the impacts are based on positions. And then the National will send it to the State League, and the state will add it to where we stand positions on issues. And where we stand is the Pennsylvania State document that identifies policy positions that can be tied to bills. So this position is how we decide which bills we endorse and don't endorse. But it is a living document, and it can change. So the bills can change, and the policies and the can change, but our position will not change. And then we will add the position to our webpage that Ann keeps up on issues and positions. And then we will integrate that position into our local program. And our local program, we will decide at our annual meeting. And those are the things that we want to be active and advocate about in the coming year. So it really is a total feedback from us at the local league to national, through to the state, and back to us. And that's what makes the league a good national organization, I think. Does anyone have any questions about that? About how that process is going to run? Okay. I'd like to turn it over to Jodine, and let me see, I have a message in here. Okay. And Jodine, I'm going to share the slides for you, and you just tell me if you want me to change them.
Okay. Okay. All right. So this slide shows you the progression of the courts from trial court to appeal court to the Supreme Court. Don't pay too much attention to the slide on the bottom, to the thing on the bottom. There are a lot of specialized smaller courts that they're not. I mean, they are federal courts, but these courts often, the judges often serve for limited periods of time, and they just do specific subjects like the Veterans Court. There's even people don't know this, but within the Federal Court of Claims, there's a vaccine court. And what the vaccine court does is, if somebody thinks that their child has been injured by a vaccine, they can bring suit in that court, and the court will decide whether the vaccine was liable for the child's injuries. That's a compromise that they made to allow vaccine manufacturers to make vaccines without fear of being sued every time somebody thought something had gone wrong. And it doesn't really get used very much anymore because there haven't been that many cases. And that's where it's been proved over and over and over and over and over again that vaccines do not cause autism. I just thought I'd mention that. But we're going to talk about these other three courts here. These are what they call the Article 3 courts. So as we talk about them, keep these words in mind: independence, transparency, ethics, and accountability. Okay, next slide. So the federal court system gets its independence from Article 3 of the Constitution. So they're called Article 3 judges. They can serve for a lifetime, as long as they behave themselves. And judges can retire. When they retire, they get their full salary as their pension. But they don't have to fear a billionaire primarying them off the court, or being castigated in public opinion. So there's a good reason for lifetime appointments. This is the primary thing that protects the independence of the court from political opposition, intimidation, harassment, and the power of the other two branches of government. But in recent years, there have actually been 2 federal judges have been murdered, and the son of a federal judge was murdered when he answered their door. Protesters have showed up at justices' homes, and they've been mercilessly harassed online. They are subject to all of those things as the rest of us. A lifetime can be a lot shorter now. Was a lot shorter when the founding fathers put together the Constitution than it is now. Now a fairly young judge can be appointed and sit on the court for 30 to 40 years. Back then, the average was 12 years. So they can be shaping the image of the court for many decades. There's been some discussion of having Congress increase the number of judges or enact a law imposing 18-year term limits. And if you watch the Nationals Town Hall, you'll hear a great deal about this. There are pros and cons for each. In the study materials, there's one brief called Structural Reforms for the Supreme Court that discuss these pros and cons. But the National League is not asking us to reach consensus on those proposals. Just know that whatever changes Congress chooses to make to the courts, those changes cannot weaken, must not weaken the independence of the courts. Next slide. Next. Okay, I'm going to tell you about the structure of the federal courts. So the district courts are the trial courts. There are 94 districts, and they're scattered around all of the different states and the territories. There's even a district court in the Northern Marianas Islands. And in my 28 years of reading federal court opinions, I never saw an opinion come out of that court. But Puerto Rico, the Virgin Islands, and Guam each have district courts as well.
Jodine, can you tell us why you know so much about this and what you did for those decades?
Oh, well, for 28 years, I wrote newsletters for lawyers and on cases as they were developing. And most of the cases were federal cases. So, you just pick up your knowledge as, over the years. So that's why I know about these things. So each district comes with a whole paraphernalia of staff. You have U.S. attorneys. Now that's the executive branch, but they're the ones who prosecute the cases. Magistrate judges who serve for specific terms are the ones who make pretrial decisions. Should this piece of evidence be admitted? Things like that. There's FBI offices, there's clerks, and there's a lot of other staff. And then each district court has a completely separate bankruptcy court, and they have all that kind of staff. Well, they probably don't have the FBI. because it's civil, but they have a lot of staff. And large districts can be subdivided into divisions, and that's going to become important when we talk about judge shopping. So you can have really small districts like Vermont, New Hampshire, Wyoming, where there's one district that's the whole state. Pennsylvania has 3 districts, Eastern, Middle, Western. And Texas has 4 districts. And each of those districts has several divisions. The Northern District of Texas, for example, has like 7 divisions. And a division is a courthouse. This judge sits in this courthouse. This judge sits in that courthouse. So the league study really raised very few, if any, questions with regard to the lower court structure. But it did raise the issue of judge shopping. So in almost all cases, judges are assigned to cases randomly, but assigned randomly within the district or the division. But you can have a situation like we have in the Northern District of Texas, where Matthew Baxmark, I think is how you pronounce his name, is the only judge sitting in the Amarillo district division. And he's a notoriously right-wing, anti-abortion, pro-gun judge. And so a lot of legal advocates, activists have filed cases in his court, knowing that they're going to get a favorable decision, and then it'll go up to the 5th Circuit U.S. Court of Appeals, which is also notoriously right-wing and probably will uphold his opinions, and then it'll go on to the Supreme Court. But last year, in the middle of last year, the Federal Judicial Conference, which is the administrative apparatus of the courts, and it's chaired by the Chief Justice of the Supreme Court and judges from all the other courts. And they issued a new rule that said that all cases must be assigned to judges randomly throughout a federal district. So in Matthew's case, a case that comes to him, he won't hear it. There'll be like 22 judges that might get assigned to that case in the Northern District of Texas. Now, you might think that the assignment of Judge Eileen Cannon to the secret papers case was also a case of judge shopping. It wasn't. The special prosecutor, Jack Smith, had to file that case in the court where the alleged crime was committed, Mar-a-Lago. And that was the Palm Beach Division of the Southern District of Florida. And she was only one of 2 judges sitting in that division. And so it was no big surprise that she ended up with that case. But the Judicial Conference rule would have prevented, if it had been in effect then, would have prevented that. Okay, next slide. So that's what judge shopping is all about. You'll see a question of, you'll see materials about it when you get the materials. Okay, so those 94 district courts, all of their decisions can be appealed to 13 U.S. Circuit Courts of Appeal. This is the middle level appeals court. 11 of those are geographical. For instance, the 3 courts in Pennsylvania, those appeals go to the 3rd Circuit, which sits in New Jersey, I think, because the 3rd Circuit also has jurisdiction over New Jersey and Delaware, as well as Pennsylvania. So the 9th Circuit Court of Appeals is a gigantic appellate court that has jurisdiction over Washington, Oregon, Idaho, California, Nevada, Arizona, maybe one other state. It's huge, and it sometimes takes 3 years to get a case through the 9th Circuit. And there's been a lot of talk about trying to break up that 9th Circuit, but it hasn't happened yet. Then there are 2 other circuit courts. The District of Columbia Circuit Court hears cases against the government, cases from the Court of Federal Claims, for example. the district court there heard a lot of the J6 cases, and then any appeals went to the District of Columbia Circuit Court. And then the U.S. Court of Appeals for the Federal Circuit is a nationwide appellate court, but it hears really specialized cases. It hears intellectual property cases. It hears patents, copyright, and trademark cases. And the patent cases are the really important ones and the really, really complex ones. You'll often hear of a ruling from the federal district on, say, a case between Samsung and Microsoft, or between Apple and Samsung. And that's pretty much what they do. That's very, very specialized. So we don't, I think they might hear antitrust cases too. I'm not sure. But at any rate, 90% of the federal cases that are appealed to the appeals court end there. Each of the appeals court cases are heard by a 3-judge panel. And if the ruling on the case is 3-0, one way or the other, they rarely appeal to the Supreme Court. If the rulings are 2-1, a lot of times they are appealed because that one judge has raised some issue that the Supreme Court wants to hear about. Some people argue that there should be 13 Supreme Court justices, one for every circuit. There are, as it is, the justices are assigned to certain circuits. Like I think Thomas, excuse me, my throat's getting dry. I think Thomas is in charge of the 11th Circuit. So if for instance, a death penalty case should come out of the 11th Circuit, he's the one that gets to decide whether the Supreme Court will interrupt that process or not. State Supreme Court decisions can also be appealed to the federal courts if they can find a constitutional issue to appeal on. And they can go all the way up to the Supreme Court. And the prime example of that is Loving versus Virginia, which was a Virginia state ban on interracial marriage. And the Supreme Court heard that case and said, no, we have freedom of association here in this country. So, you can't do that. One can, to a certain extent, appellate court shop. Any case filed in the Texas federal courts, for example, or the Louisiana courts, will be appealed to the right-wing Fifth Circuit. And sometimes it goes on from there to the Supreme Court. One case in which the Fifth Circuit, the Fifth Circuit found that the drug Milfaprex that the FDA had mistakenly ruled that Milfaprex, which is an abortion drug, was not a safe and effective drug. The Supreme Court took it up and said that, and reversed them on the basis of standing, because they couldn't prove this was a group of doctors who couldn't prove that they had been harmed by it. Okay, next slide. The U.S. Supreme Court. This is where I think most of our deliberations are going to take place. So the U.S. Supreme Court hears 60 to 80 cases a year. They can decide what they want to hear, and they turn down almost everything. So there's the normal or merit docket. Now, docket is merely a listing of the case. It lists all of the documents in the case, the motions, the orders, the briefs, and all of that. And you can follow along that docket as it's developed if you want to, and you can see who's been filing amicus briefs, for example. That was always a very interesting thing to me. But the court takes up cases on the merit docket once they have been a final decision in the appeals court. But so the shadow, and in recent years, they've been using the shadow docket more and more. It's also the shadow docket's also known as the emergency docket or the rocket docket. In those cases, the judges can reach down into the lower courts where there has not been a final decision made and say, oh, we're going to hear this. And then usually it's heard on an emergency basis. They don't take months and months and months to bring in briefs. There's no oral arguments. They may not publish a written opinion. And when they do, they may not explain themselves and they may not sign it. So that's an instance where there's no accountability. So I would say the normal docket, when the court follows the normal docket to a decision, that fosters transparency and ethics and accountability. The shadow docket's the exact opposite. The shadow docket fosters secrecy and mistrust of the court. Oh, I want to give you an example though of a case that's the Trump administration is trying to get onto the shadow docket right now. A Seattle judge issued an injunction negating Trump's executive order doing away with birthright citizenship. And then so the administration took it to the Ninth Circuit. The Ninth Circuit said, we're not going to hear this case because it's not an emergency. They said it was, it's an immigration emergency. We have to get this resolved. The Ninth Circuit said, no, it's going to go according to a normal docket. Now, I think the Trump administration will then try to appeal to the Supreme Court to take it as an emergency case and put it on the shadow docket. But I'm very doubtful that they'll do that because it's such a basic constitutional principle that's been there for 150 years. And I don't think there's any rush to judgment on that. But we'll see. We'll see what happens there. Okay, next slide. Next slide. Legitimacy. So this is another one of the words, I guess, integrity, ethics, legitimacy. So, as Andrew Jackson once said, the court has no army to enforce its opinions. It doesn't. It has only its own authority and public opinion. But unpopular decisions damage the court's legitimacy and erode popular support of its decisions. I'm going to talk about these three cases, but right now there's a great worry and debate around the question of what happens if President Trump refuses to obey a ruling of the Supreme Court. He has said that he will obey lower court rulings that have gone against him, but he's also said he will appeal. I think the thinking there is that he's banking on his Supreme Court ruling with him every time. But what if it doesn't? This is completely uncharted territory. It would be a constitutional crisis of great magnitude. It's never happened before, not even when Andrew Jackson made that side remark about the court not having an army. So we don't know what's going to happen there. I think that if Trump refuses to obey the Supreme Court and nobody does anything to stop him, that's the end of our democracy. In fact, the court relies on the other two branches of government to confirm its legitimacy. For instance, in Brown versus the Board of Education, the desegregation case, it had to rely on the executive branch, the National Guard, to enforce its ruling. That was a very unpopular ruling in the South and West and led to a vigorous campaign to impeach the Chief Justice, Earl Warren. I remember seeing the billboards on the side of the road saying, "Impeach Earl Warren." That didn't go anywhere, but it was very, very vigorously sought after. But the public came to change its mind about Brown versus Board of Education. So that was an example of public opinion coming around. And even when the court overturns a law or something that Congress has passed, it often will say to Congress, go back and fix this. For instance, West Virginia versus EPA, the Supreme Court says that Congress did not give the EPA the authority to regulate greenhouse gases in existing power plants to mitigate climate change. What it was saying was, hey, Congress, if you want to do this, if you want the EPA to do this, go and change that law. But Congress very rarely, if ever, does that because of partisan reasons. Can't get anything done in Congress for that reason. So even though the justices' lifetime appointments means they're not swayed by public opinion is very important. That since Citizens United in 2010, the court's popularity rating has plummeted. Approval rating has plummeted from 58% to 41%. And I just saw on TV last night that it might be down to 31%. The Citizens United decision allowed unlimited dark money in political campaigns as a form of free speech, which has culminated in what we see today. We have the richest man in the world being allowed to rampage through our government because he spent $244 million to buy the election of the current president. Dobbs, as you all know, Dobbs overturned Roe v. Wade and has essentially made women in certain states second-class citizens, while women in other states enjoy full reproductive rights. That's a very unpopular decision. And Trump versus the United States, the court handed the president carte blanche to do whatever he wants to do as long as he calls it an official action, regardless of federal employment laws and collective bargaining agreements and other laws. So that's a very unpopular opinion. All these unpopular opinions dragging down the popular approval of the courts and injure its legitimacy. Okay, next, transparency. The federal court system is fairly transparent as in its normal function. For instance, if you want to go and read any of these cases that I just mentioned, all you have to do is get on to www.supremecourt.gov, and you can read the whole case, all the opinions, the orders, the whole docket. It's all there, and it's all free. But that's only the case with the Supreme Court. For all of the federal courts, we have PACER, Public Access to Court Electronic Records. Now, you can get free opinions of lower courts off of PACER, but any other documents, you have to pay 10 cents a page to access the dockets and the documents. For instance, I went and got the complaint against the discrimination complaint against Tavola off of PACER. I have my own personal account. You have to put up a credit card, but I don't use it. I hardly ever use it because it's so expensive. And many people argue that there's no reason for it to be that expensive. Maybe a penny a page would be better. Also, I want to mention that the federal courts do not allow trials or hearings to be televised, but for the most part, they're pretty accessible. You can, you can go and sit in a trial. You can, if you want to travel to wherever they're sitting, you can sit in the appeals courts oral arguments. I have been down to Washington to sit in on Supreme Court oral arguments. And on the Supreme Court site, you can get transcripts of oral arguments. But PACER is the place that news reporters follow, That's the place where they get all the documents that Rachel Maddow and Lawrence O'Donnell read to you every night. That's where those documents come from. Let's see. And PACER is searchable across every district and appeals court throughout the country. When I worked at Westlaw and had almost unfettered access to PACER, and Trump was in his first term, I once asked it to find all the cases throughout the country where Trump was a plaintiff or a defendant in a federal court suit over the last 10 years. Well, when the system got to 2,500 cases, it announced to me that it was going to start charging me for the search. So I abandoned it at that point. But, you know, in a lot of those cases, he was just named because he was the president. That really didn't involve him. So, you know, even though cases, trials and hearings are not televised, there's reasonable transparency. There is one totally secret court. That's the FISA court. It's a special court presided over by a panel of, I think, 3 federal judges. The FBI and other intelligence organizations will go to the FISA court to get warrants to conduct surveillance against citizens, and even then, electronic and physical surveillance. Even then, any persons that they target, if they come up with evidence of a crime, that person has to be tried in a regular district court. But a lot of people feel that the FISA court is an abusive entity that allows the FBI to spy on citizens without oversight. Well, the most famous case there is Carter Page. He was the oil consultant who had bragged to somebody overseas that the Trump campaign had a lot of Hillary's emails, and so the FBI went and got 4 warrants to surveil him. They did surveil him. They brought him up on some really. They didn't get any. They didn't find anything though, and they brought him up on some really bullshit charges, and he was completely exonerated. But you know, he had to have spent a lot of money on lawyers and things like that. So I guess the FISA court can be a bit of. Okay, next. The U.S. Judicial Conference is the conference that I told you about earlier that administrates the courts, and it creates and enforces the codes of ethics that all of the justices and judges are supposed to follow. But the unique problem for the Supreme Court is that there's no entity above it to force it to enforce its code of ethics. Now, Justice Roberts last year did try and establish a much stronger code of ethics for the Supreme Court justices. There are mechanisms to reprimand and punish lower court judges all the way up to impeachment and removal. For instance, last year, the Judicial Conference suspended appeals court judge Pauline Newman, who's 96 years old, for a year while it investigates whether she can still perform her duties on the Court of Appeals for the Federal Circuit. But remember, that's the court that hears all the patent cases. I don't think I could perform her duties at 50, but apparently there's a feeling that she is kind of gotten, she might have some dementia. So we'll see what happens. They're still investigating that. And then all of the judges, including the Supreme Court judges, can be impeached, just like the president, and for the same reasons: treason, high crimes, and misdemeanors. Vice President Vance has talked about impeaching all of the judges ruling against the Trump administration. Now that would destroy, if that happened, that would destroy the independence of the courts. But it's very unlikely to happen. And as a Yale law school grad, Vance knows that. That's just his way to intimidate the judges. Historically, Congress has been very reluctant to impeach judges. Only 15 federal judges have been impeached and removed in the entire history of the courts. Most judges accused of crimes and misconduct resign before it gets to impeachment. Samuel Chase was the only Supreme Court justice to be impeached in a fierce fight with Thomas Jefferson over judicial power. Chase thought that he could act like the prosecutor and the judge. So they impeached him on several counts, but the Senate acquitted him on all of the charges. And even if Congress were to try to impeach the judges that are now standing up to Trump and Musk, they would have to present grounds other than that they were doing their jobs. That's what they're doing, their jobs. Okay, next slide. Supreme Court ethics issues. So yeah, we've all heard about this, how judges have failed to report gifts, some pretty extravagant gifts, trips, there's spouses, finances, and conflicts of interest. So last year when Chief Justice Roberts put in the new Code of Ethics, they also established, or it might have been there before, but I don't know about it, a website where you can go and look at their financial and conflict of interest reports. And that's there on the screen, pub.jeffs.uscourts.gov. And you probably could find it just by searching Google. But the thing there though is that it's all voluntary, and we don't know if they're reporting everything. Thomas has come back, I think, 3 times now to report, oh, one more trip, So these issues, the failure of judges to recuse themselves, the failure to report gifts, and the sham nomination process that they go through in Congress too. These all erode the legitimacy and the independence of the Supreme Court. The Federal Judicial Code of Conduct requires judges to recuse themselves from cases under several in specific enumerated circumstances. For instance, if a judge has a financial or personal interest in a case, or acted as a lawyer or as a judge in a case in a lower court, they are required to recuse themselves. Justices Alina Kagan and Sam Alito recuse themselves most often from Supreme Court cases. Justice Kagan often explains her decision, while Judge Alito never does. Often the issue is that they have sat in on the case at a lower level. For instance, when Justice Jackson was appointed to the court, she had to recuse herself from several cases that had come up through the normal process when she had sat on the appellate court. Or the judges may recuse themselves if they have a family member who has an interest in the case, or if they own stock in one of the parties in the case. There are a number of specific things that they should recuse themselves for. When a lower court judge recuses, it's a simple matter to substitute another judge from the same court. The parties can also petition the appeals court to force a trial court to recuse for any of the reasons in the Code of Conduct. In fact, I believe that they did try to get Judge Cannon off the secrets case, but the 11th Circuit Court of Appeals said no, she was okay. At the Supreme Court level, recusal is completely voluntary, and it could change the outcome of a case. If, for example, a judge recuses and the court splits 4-4 on a case, the lower court decision is upheld. In many cases, though, the decision is going to be unanimous or close to it, and the recusal of one justice does not alter the outcome. Justice Thomas faced a firestorm of criticism for failing to recuse himself from a case, Fisher versus the United States, involving the January 6 rioters, despite disclosures that his wife organized and paid for buses to come to Washington on January 6th. The decision in that case was 7-2, so Thomas's recusal would not have made a difference. He did recuse himself from another J6 case in which he and his wife were mentioned in emails between the parties. that became evidence in the case. I think the judge, I think the court denied certiorari in that case, so they didn't hear it. Okay, next slide. The stability of the court. You want your courts to be stable and make decisions that kind of build on earlier decisions. So here in this country, we have a principle called stare decisis, which means let the thing stand. So, so the principle of stare decisis is that the court should be bound by prior decisions or precedents that have been decided on similar facts and law. And there are two kinds. The vertical kind is where the lower courts are bound by decisions of the higher courts. Now, this vertical precedents are no problem because the appeals court, if a district judge wanders away from a case that his appeals judge has decided, his appeals court has decided, the appeals court just slaps him down, just sends the case back, says you didn't decide this on this basis, do it again. So there's no problem there. It's the problem comes in when it's horizontal, which means the same court upholds its earlier decisions. And of course, the most famous one of those that we have is Roe v. Wade and Dobbs. I think you all remember how many of those judges, when they were going through the nominating process, said, "Oh, Roe v. Wade, it's settled law. Yeah, no, we're not going to touch that." And then now you remember how many of them actually did. And again, when controversy over precedent gets to the Supreme Court, it becomes an issue because there is no higher court to overrule them, unless Congress makes a new law. Dred Scott stood until the 14th Amendment was adopted. But the thing I want to point out to you, because we have a question on this, is stare decisis should not be an absolute. It is sometimes beneficial to society to overturn an earlier bad precedent, and the gold standard on that is Plessy v. Ferguson in 1876. Where the court decided that segregation was allowed as long as public conveyances provided separate but equal facilities. That led to 100 years of Jim Crow laws. Then Brown versus Board of Education overturned that, calling for desegregation of the public schools, and that led to the Civil Rights Movement. So there are some instances in which stare decisis is not sacred. So just so you'll be aware of that when we answer those questions. Okay, I think I've covered everything I wanted to tell you about the courts. Now we're going to go on to the study questions themselves. So I think you saw this slide earlier. When we meet, we'll all indicate whether we have a strong consensus for, or moderate consensus for, strong consensus against, moderate consensus against, or no consensus. And in this process, we'll be discussing it, and there'll be a place where if we have a reason for going against the grain here, we can actually write in to tell the LWVUS what we're objecting to, or the wording or something like that. Okay, next. So the first four consensus questions are about those four principles that Kathy and I outlined. And the remaining questions deal with more specific aspects of the workings of the federal judiciary. So the first four questions are these: transparency, accountability, independence, ethics are all essential to an effective federal judiciary. Yeah, can we go back to that for just a second? I mean, this seems kind of obvious, and kind of milquetoast maybe. But don't forget that what we are doing is we are establishing our principles as a league, which we are going to base all of our actions going forward. So, you know, and we don't know what may come up in the future, but we know that we'll know that transparency is important, you know. So that's why those questions are worded the way they are. Okay, next. All right. Again, these kind of seem obvious. There should be binding universal standards of conduct for judges and justices. Everything should be public. That's not necessarily the case, but most things should be public. There should be an effective enforcement mechanism for the federal judiciary code at all levels. That's, you know, we'll probably agree with that. What I meant by question 6 is there are instances where the courts have to seal information. Sometimes they'll have to seal a complaint because there are people who are going to be charged who are not aware that they're going to be charged. So they have to keep that a secret until they're charged. Sometimes the court will seal corporate documents because they might reveal trade secrets. And in those instances, there's information that should not be made public. But I would say overall, and for 99% of all of the activities in the court, that it should be available to the public. So, you know, I'll be arguing this at the meeting, so so you can expect that. All right, next one. Yes. So an enforcement mechanism should include a process to require a judge or justice to recuse himself. Yes, we already have that in the lower courts. I explained that to you, that in the code of conduct, there are about 8 or 10 specific reasons why a judge should recuse himself. That the appeals court can say, yeah, you know, you did this. You represented this guy in another case, so you shouldn't be sitting on this guy's case. They're very specific, and you know they're in there and they're followed. But again, the Supreme Court. A judge or justice's decision or rationale to recuse or not recuse should be publicly disclosed in writing. Yes, definitely. Always. The question 10. Federal judges and justices should be subject to rigorous financial disclosure requirements. Yes, of course. Enforcement and penalties. Yeah, we should have them. Stability of the law. This is one that I've already taken a little bit of an issue with. That stare decisis is a value that contributes to strong democracy. It does, but it can't be absolute. You know, or we end up with, you know, like the judges will go back to what they thought the forefathers were thinking in 1789. Public perception. Yeah, okay. We'll talk about that. Next. Okay, these are the next steps. We've already told you the consensus meeting itself will be Saturday, March 8th from 1:30 to 3:30 at the Ridley Library. We will send you all of these materials, and we'll send you the link to LWVUS League Management where you can get them. And then once we have you know, decided what we want to decide and send it off to the council at LWVUS, it'll be announced in June. So, yay! Thank you so much for sitting through all that. I hope to see you all on March 8th. Now that you have the background, you're going to be able to really contribute to the consensus meeting. And so was there anything else we wanted to say, Kathy?
I just want to thank you again, Jodine, for putting this together. It was a lot of work, and I learned a lot. I say thank you, Jodine. Now there's a lot of material that we can look over, and we have experts like Jack Nagel. I hope that you can make that meeting to fill us in on other things. So please take a look at the resources, and please come. When we do our consensus, only people who are at the meeting can participate in the consensus. In other words,
Yeah.
you can't just answer those 12 questions and email it in to us.
Yeah, and take a look at the briefs. If I've confused you about something, you're not sure about it, take a look at the briefs that talk about that issue, so you can be sure of what you know when we go into.
I think one of the great things about the league is that it's always a learning experience. And I
Yes.
learned a lot today, and I learned a lot from those resources.
Absolutely.
You know what? There were questions. Let me run and get them. Okay. If we have time, do you think we have time?
Yeah, people can leave if they need to leave, but we can keep recording. Ann, did you have something you wanted to say?
Yeah, I wanted to ask about that date again. What was it? March, was it?
March 8th.
The 8th. Okay. I just want to write it down on my calendar. Thank you.
And you'll get
I know I'm going to get that. Yeah.
Yeah.
I just want to make sure I'm prepared for it.
So
Thank you.
we prepared a sign-up sheet just so we know approximately how many people are
Right.
coming, because we have to go in and
Wonderful.
set up the room ahead of time.
That's a Saturday. Did
Yes.
you know that?
Yes.
Okay.
We decided to do it Saturdays so that people who are working and have school or have kids in school, their weekdays are pretty
Thank
full.
you.
Okay.
I did have a question that I don't think I wrote before. May I ask you if
Sure.
they wanted to change anything about the Supreme Court or any judicial court, that has to go through the House. Is that
To
correct?
the whole Congress, I think.
The whole Congress, Senate, and the House.
Yeah.
Oh wow. Okay. I
So,
don't
yeah,
think that'll ever happen.
that's
but
why nothing ever gets changed about the court.
So Jack,
It
chime
would be
in.
wonderful.
Chime in, Jack, if
Thank you.
you have to unmute yourself.
Thank you, Jodine. That was tremendously informative. I'm curious about one question, and that's why are we not asked to address the question of term limits? The proposal of a distinguished commission for 18-year terms with a regular process would be a tremendous improvement.
Well, you'd have to ask LWVUS why that is. But if you watch the national town hall that we have the video on, there's a great deal of talk about that.
There really is.
I was expecting that we would be asked about that, but I think maybe we take this consensus, and then we go out and we say, now the league has a position on the courts, and under our position, we favor the 18-year term limit.
I think that the consensus in general is about principles.
Yeah.
And then we take those principles that we agree upon nationally and we apply them to specific resolutions and proposals.
Very good. Very good.
And, yeah, maybe that's the first thing we'll do.
But they did spend a lot of time on that. You're right. 18-year. They spent a lot of time on
And
it.
the paper, the brief that they prepared is very good on that too.
Yes, it was. Yes, I agree.
So a question I have here is how can ethics codes be enforced, especially for the Supreme Court? I think that goes back to the judicial council. They have to figure out a way to how to do that. And don't forget, they're chaired by the Chief Justice. And I think he has a great deal of influence over how that can be done. But the only thing I can see is impeachment.
Right.
Let's impeach Thomas.
Oh, that'd be wonderful. Yeah.
Roberta, did you have a question? You have to unmute.
I was going to say we can always amend a position once it's adopted. So that might be something we might bring back to the National Convention to amend the position once it's adopted in the following period.
Good
Okay.
point.
Right.
So I think we answered this question about how we're working nationally with this report. Each league fills out a form reporting that have their consensus, gets sent to this council of the National League. They compile it, and then they make a final report to the board of the LWVUS. What can be done to improve judicial ethics reporting, financial disclosures? Well, I do think that the idea that there is a website where you can go and look at their financial reports is extremely helpful. People with knowledge of say, what Thomas did can look at those reports and say, oh, wait, he didn't report this trip. He didn't report that Winnebago. So having public knowledge of it, of them, specific public knowledge, helps to keep them honest there. What enforcement measures can the courts take if the current administration refuses to comply with their decisions? That's the question, isn't it? And how do we protect the judiciary? Well, hopefully we'll adopt these positions, and then we'll be in position as an organization to defend and support the Supreme Court. So, any other questions?
Rosemary put a comment in the chat that your presentation was amazing, like a law school class. I felt the same way.
I feel like after all these years, I probably could take the a federal bar exam with no sweat.
Anybody else? Well, thank you so much for coming, and we really do look forward to having you join us for this consensus.